It is 6:52 on a Tuesday morning in Anchorage, and the man in the back of the unmarked Chevrolet Suburban has spent 11 years arguing cases in Alaska's courts. Today, he isn't the attorney. Today, he's an A-file number, a wrist zip-tied to a nylon belt. A name an agent who has never heard of him is typing into a federal detention database. The heater is running. Outside, the temperature reads 19 degrees. Nobody in the office building he reports to knows he's gone. His name is Daniel Osei Bonsu. He is 41 years old, an assistant attorney with the state of Alaska assigned to the civil division. For a decade, his job has been to represent the state, the government, in court. This morning, the government came for him. By the end of this story, you'll understand why a man who spent 11 years working for the state of Alaska could be held for weeks in a federal facility with no criminal charge against him.
You'll also understand why the one document that could have ended it in a day sat in a scanning queue in Missouri while his case moved through 3 agencies, each assuming another one was handling it. That document matters. Hold on to it. Here is what doesn't fit. Daniel Osei Bonsu is not undocumented. He entered the United States legally in 2009 on a student visa, earned a law degree, adjusted his status, and has held lawful permanent residence, a green card, for years. He passed a background check to work for the state. He passed the Alaska Bar's character and fitness review. The same government now holding him fingerprinted him, vetted him, and cleared him. So how does a green card holder end up zip-tied in a Suburban at 7 in the morning? The answer starts with a clerical event most people never think about. A green card expires. The physical card, not the status, the card, has a 10-year shelf life, and renewal is a paperwork process that routinely drags on for 18 months or longer. Osei Bonsu had filed his renewal. He had the receipt notice that legally extends the card's validity. On the morning of the arrest, that receipt notice existed as a PDF, in an email, on a laptop, in an apartment he was not allowed to go back to. His legal status was real. The proof of it just wasn't in his hand. The encounter that started it happened 3 days earlier. A traffic stop on the Glen Highway just outside Anchorage, a busted taillight, an expired tab. The trooper ran his license. Everything came back clean on the state side. But somewhere in the data-sharing pipeline connecting local law enforcement to federal immigration systems, a flag surfaced. The physical card on file had passed its expiration date, and the renewal, filed with U.S. Citizenship and Immigration Services, had not yet propagated into the database Immigration and Customs Enforcement queries. To the system, he looked like a lawful permanent resident whose card had lapsed and whose status couldn't be confirmed instantly. That's the gap. That's the whole story, and everything that follows lives inside it. The trooper didn't arrest him. The traffic stop ended with a citation and a handshake. But the query had already been logged. And in the modern enforcement architecture, a query doesn't disappear. It becomes a lead. Somewhere in an ICE Enforcement and Removal Operations field office, that lead landed on a target list, and 3 days later, a 2-agent team was dispatched to a parking lot to make contact. They didn't come to his office. They came at dawn to the lot outside his apartment complex and waited for him to walk to his car. He was carrying a travel mug and a leather work bag, wearing a coat over a collared shirt. By every outward measure, he was a man on his way to work, which he was. The agents identified themselves and asked his name. He gave it. They asked about his immigration status, and here the whole thing pivoted. He told them the truth. He said he was a lawful permanent resident. He said his renewal was pending. He said he could show them the receipt notice if they'd let him go upstairs and get his laptop. They said no.
Under ICE field procedure, an agent isn't required to accept a verbal claim of status. Once someone is identified as a target of an operation, standard practice is to complete the detention and sort out documentation later, at the processing center, not in a parking lot at dawn. It's a procedure built for a different kind of encounter.
Applied here to a man telling the exact truth, it produced an outcome nobody in the chain actually intended. Agents placed him in administrative custody and transported him to a holding facility for processing. And this is where the gap tightens. The one document that proved everything, the I-797 receipt notice, sat minutes away, upstairs on a laptop. He couldn't get it. His phone was bagged as property. The agents in front of him had no way to pull the receipt from a federal database because the renewal hadn't finished propagating into the system they could see. The truth existed. The system couldn't read it. Remember that. By 10:40 that morning, word reached the 4th floor of the state office building downtown. A paralegal noticed Osei Bonsu had missed a status conference, something he never missed, and couldn't reach him. A colleague called his cell and got the property room voicemail. Within the hour, the information climbed to the office of the Alaska Attorney General, and at 11:52, the Attorney General of Alaska was told that one of his own attorneys was in federal immigration custody. He got what almost no detainee ever gets. The second most powerful lawyer in the state picked up the phone on his behalf within 6 hours of the cuffs going on. That phone call didn't end it, and understanding why is the center of this whole story. Immigration detention is administrative, not criminal. There's no bail hearing on the first night. There's no arraignment. Once a person is booked into ICE custody with a pending status question, releasing them requires either a formal determination by the agency itself or an order from an immigration judge, and immigration judges don't work the night shift. The state's top lawyer could make calls. He couldn't make the system move faster than its own paperwork. So the calls started. The Attorney General's office contacted the ICE field office director for the region. They contacted the local congressional delegation. They contacted USCIS to request expedited confirmation of the pending renewal. Every one of those calls hit the same wall. The receipt notice, the proof, was filed, real and valid, but it lived as a physical document in a USCIS processing workflow. The electronic confirmation that would satisfy ICE had to be located, verified, and formally transmitted between two agencies that don't share a live database. The document sat in a scanning and verification queue at a USCIS service center in Missouri. It was going to take days, not hours, days,
for a piece of paper everyone agreed existed. Meanwhile, Osei Bonsu was moved. Alaska has no large-scale ICE detention facility of its own, and detainees held past a short processing window are frequently transferred to contract facilities in the lower 48, most commonly the Northwest ICE Processing Center in Tacoma, Washington, a 1,575-bed facility run by a private contractor under a federal contract. By the second day, the man who prosecuted and defended cases for the state of Alaska was in a dormitory unit 1,400 miles from the courtroom where he was supposed to be that week, wearing facility-issued clothing, waiting for a database in one state to talk to a scanner in another. The days inside that unit looked like this. No privacy in a dormitory pod, bunks in rows, fluorescent light that never fully goes dark, meals on a fixed schedule, and a bank of shared phones that require a prepaid account and connect only to numbers already cleared through the facility. A man who had spent a decade cross-examining witnesses about the fine points of procedure now stood in line for a 15-minute call, watched by a guard, unable to explain in legal terms that anyone in the room could act on. His training was worth nothing here. The one skill that had defined his professional life, the ability to marshal a document and make an argument, was exactly what the facility was built to take away from him. This is the part the early news coverage got wrong.
When the story first leaked to an Anchorage television station on day 2, the framing was political, a fight between a state government and a federal agency. That's a good story. It isn't the real one. The court filing that came later tells a different version, quieter and worse. Nobody in this chain was a villain. The trooper followed protocol. The agents followed field procedure. USCIS followed its processing workflow. ICE followed its detention rules. Every link in the chain did exactly what it was trained to do, and the sum of all that correct behavior was a lawful permanent resident sitting in a private detention center because a PDF hadn't finished scanning. The system worked exactly as designed. That's the problem. On the third day, the Alaska Bar Association issued a public statement. It didn't take a political side. It said a member in good standing was being held in immigration detention despite holding lawful permanent resident status, and it called for immediate review of his case. The statement did something subtle and important. It put the weight of the state's legal profession, every judge, every prosecutor, every defense attorney who reads bar communications, behind a single detainee. Most detainees have no such backing. Osei Bonsu had an entire bar. And still the machine ground at its own speed. His attorney, an immigration specialist retained by colleagues who pooled the funds, filed a request for a custody redetermination hearing before an immigration judge. Under the process, that hearing is where a judge reviews whether continued detention is justified. But the immigration court docket for the Tacoma facility was backed up, and the earliest available slot was 6 days out. 6 days. His lawyer filed for an expedited hearing on the grounds that the detention was based on a documentation gap, not a status defect. Why couldn't he just show them the receipt? He had it. It existed. The answer is the cruelest mechanical detail in the entire case. He couldn't access his own email from detention without going through the facility's monitored, restricted system. Even after his outside attorney obtained the PDF from his laptop and emailed it to the field office, an emailed copy from a detainee's personal laptop isn't, under ICE's evidentiary standard, the same as a verified status confirmation from USCIS's system. They had the document. They still needed the government to confirm the government's own document. The proof and the acceptance of the proof were two different things, sitting in two different agencies, waiting on a queue. The single document sitting in a scanning queue in Missouri pays off here. On the 5th day, a USCIS supervisor at the Missouri Service Center, working a batch of expedited requests flagged by the congressional inquiry, pulled Osei Bonsu's file. The renewal was there. It had been there the entire time, received, fee paid, biometrics completed, sitting in a normal processing lane behind tens of thousands of other applications. The supervisor did the one thing the whole case had been waiting on. She generated the electronic verification of the pending application and transmitted it directly to the ICE field office and the immigration court. It took her, according to the later filing, about 20 minutes. 20 minutes of work, sitting behind 5 days of queue. That's the entire distance between a state attorney at his desk and a state attorney in a detention dormitory. Not a policy, not a conspiracy, a place in line. With the verification in hand, the picture changed instantly. The expedited custody hearing was moved up. On the 6th day, an immigration judge reviewed the confirmed record, lawful permanent resident, valid pending renewal, no criminal charges, no removal grounds, and ordered Osei Bonsu released from custody. The order was administrative and undramatic. A clerk read it into the record. No gavel, no crowd.
He signed for the return of his property: one phone, one leather bag, one travel mug that had been sitting in an evidence locker in Tacoma for the better part of a week. He flew back to Anchorage on a commercial flight in the same coat he'd been arrested in. The aftermath is where the uncomfortable facts live, the ones the relieved press release didn't include. Osei Bonsu was released because he had a green card, a receipt notice, an attorney general, an entire state bar, and a congressional delegation making calls.
Strip away any one of those, and the timeline gets longer. Strip away all of them, which is the situation for most people held in that same Tacoma facility, and 5 days becomes 5 weeks, or 5 months, over the exact same kind of documentation gap. His release didn't fix the gap. It just proved he was well connected enough to survive it. There's one more detail the coverage mostly skipped.
During his detention, 3 of his active cases were reassigned to other attorneys, and a colleague completed one time-sensitive filing by working through a weekend to make the deadline. She didn't know when she started whether Osei Bonsu would be back in a day or gone for months. She rebuilt his argument from the case file, matched his citations, and filed it under her own signature, so a client neither of them had met wouldn't lose emotion because of where the lawyer happened to be sleeping that week. The state of Alaska, the same government that detained him, kept his work moving in his absence because the legal system he served couldn't pause just because one of its lawyers had been swept into a different arm of the same government. One hand of the state was filing his motions, while the other hand held him in a cell. After his return, the Alaska Attorney General's office and the state's congressional delegation opened separate inquiries into how a lawful permanent resident with a pending renewal ended up in prolonged detention.
USCIS acknowledged that electronic verification of pending applications doesn't propagate to ICE systems in real time, and that the gap can leave lawful residents unable to prove their status during exactly the kind of encounter Osei Bonsu experienced. No agency admitted fault, because under the rules as written, no agency committed one. That's the finding. Osei Bonsu went back to work. He argues cases again in the same courts for the same state. His green card renewal was approved a few weeks after his release. The new card arrived by certified mail, and he signed for it at his own front door, the same door he'd been walking away from when the agents were waiting in the lot. He keeps the receipt notice now. Not on a laptop, not in an email. A printed copy folded in the inside pocket of the coat he was arrested in. The one document that was true the entire time. Close enough to touch, and for 5 days worth exactly nothing, because the system that issued it couldn't read its own handwriting fast enough to let him go home.